This is Hap May with a legal play.
And I'm Chelsea El-Azzi, Hap's associate. Hap, we've got a couple of clients who have IRS liabilities.
Yes.
And they may even have IRS judgments against them.
Well, IRS judgment is one thing, the lien's another.
So let's say you've got the IRS coming after you for debts they say you owe.
Right. And there's a process by which taxes are assessed. And that's usually you file a tax return. You say you owe so much. The IRS then kind of processes that, and that's an assessment. The other way to do it is the IRS audits you, makes some adjustments, and there's a process for which you can challenge the adjustments with the IRS in court. But assuming that plays out, then they make an assessment based upon the audit. Also, in cases where people have not filed tax returns, the IRS has the right, after making some attempts to try to get them filed in an ordinary course, to go ahead and force file a return and sometimes make up numbers.
Yeah.
And make an assessment based upon that. So we are dealing today with the assessment, however it is done, is already made.
Right.
And now we've got revenue officers who are collectors, tax collectors, who are going to try to collect that tax which has been assessed.
We've got previous podcast topics and blog pages about, how do I know if I'm being audited and the assessment portion of that. So now we're at the point where, as Hap says, you've got revenue officers attempting to collect. So today's topic is, what can IRS collections do and how should you react?
Right.
So the case that's kind of weighing on my chest right now, and I will not go into details about the client specifically, but it does tend to be repeated with different clients, is there might be some large assessment that the IRS is trying to collect on. And if you can try to run from it, we have, said that that's an option that we might not always recommend.
I'm not actually running from an IRS agent as they're approaching your house, but yes, there are.
But if they know where you live, you're not planning on moving, and you want to, kind of face this, the IRS is, my understanding is the IRS is going to want to know, okay, well, how much can you pay? And let's say, the client wants to to work with the IRS.
Right. And wants to get paid off. And then there are some debts that, recognize you're going to have to pay. That's something that you could pay, although it'll be painful and take a long period of time, in which case we can negotiate installment agreements, which will basically take the taxpayer has to make a series of disclosures in what they call a Form 433A about his personal effects. If he has a business, a Form 433B to show what the business income, expenses, assets, liabilities all are, and the IRS will take that and calculate how much you should pay monthly and how much is available to be paid over a monthly without causing you undue hardship, and also what would keep your business going.
Well, and so the client I'm thinking about in particular, business is no longer, and he's getting close to retirement. And so there's no real active business income coming in. And in a lot of our cases, not just this one client I'm thinking of, there's value in the house. They've got their homestead, their personal residence that maybe he or she, taxpayer, or them with a spouse, is living in. And maybe that's like their main, asset with any kind of value. You still have to disclose the equity and the value.
Disclose that. The IRS likely will file a lien in whatever county that's located in. And once the lien is there, it has the same effect as a judgment. And you cannot sell that house and give somebody a title policy saying that the house is free and clear of liens without paying that amount to the IRS or by some other mechanism getting the IRS to release that.
Okay, before the IRS files that lien, you could work with the IRS and say, okay, well, I want to avoid any lien on the house, and I'll just agree to make installment payments to the IRS? Would they still be able to put?
Right, yeah, the IRS is gonna be very reluctant to do that. Because they would be, they want to compromise their position with regard to whatever equity there is in the property. Property was subsequently sold, if the guy has another judgment against him, or some other lien placed on his house, that would diminish the IRS's equity lien position with regard to that. So that is a tough sell.
So are you saying that the taxpayer would not be able to enter into any kind of offer in compromise or installment agreement without there being a lien on the house?
In most cases, that is unlikely.
Okay, well, so to back up a little bit, if you're going to make installment payment, like let's say you just want to say, okay, I recognize I have this responsibility to pay, and I want to just be a good citizen and start making installment payments. Part of the value of what they would ask for monthly is the value in the house, correct? Am I understanding that? That you'd have to say.
No, not necessarily. In an offer in compromise situation, they would look at the value of the house.
Okay.
And so how much equity is there in the house, and that should be available. Because if you owe the IRS, let's say you owe the IRS more than you can pay, you owe the IRS $5 million, just to pull a number out of the air. And I mean, maybe you make, $80,000 a year, and you've got, $300,000 of equity in your house. You can't pay the $1 million, but there's $300,000, and you probably can afford to pay I'm making up a number here, $20,000 a year once you look at your expenses and stuff like that. So the IRS will say, okay, for the next 5 years, you pay $20,000 a year, and figure out some way to pay us $300,000, add those two numbers together, and we will accept that. That's kind of offering compromise math, where the value of the house becomes an important element in that. Now, as we've come up with in a number of cases, that's not just the taxpayer's house. If that is a community property, co-ownership arrangement, it is all husband and wife's.
Yeah.
Equity in that house has to be paid to the IRS.
And this was a question we had to research, because in a community property state, yes, they are joint owners of the whole, but in terms of like being able to devise your interest in the house, at your death, it kind of goes 50-50, and you only have half of that equity to be able to do anything with. Your spouse maintains the other 50%. So you would think that it would be the same with the IRS, that the IRS would only be able to look at, the spouse's 50% interest in the value of the house.
It's not.
Yeah.
Yeah. And of course, if it's a community debt, if both taxpayers are on the hook for the taxes, that doesn't make any difference to both.
If they're married, filing jointly, I think there are like steps you can take up to that, where maybe you've got some kind of, premarital or postnuptial agreement where husband
does not have a community or other co-partner interest in the other partner, be it a spouse or something else, then where the taxpayer only owes that. Now, if they were smart, not smart. I mean, if they
had anticipated and taken steps.
Well, and early on in their marriage or before they got married, they did that split so that there is no community property that ever existed. And later on, they had taxes. That's not a problem. We get a lot of people that come here and say, okay, well, let's do a post-nup right now, because we know we owe the IRS a bunch of money, and then a couple of years later the IRS starts to foreclose on the house, and they say, you hold up this thing. No, it's not hers, but you did it in anticipation. And there's some fraudulent conveyance doctrines that apply, and so the IRS, if you make that change in the character of the ownership too late in the process, the IRS and many other creditors could be able to shoot through that.
And Hap will know when that line has passed, when you're at that point where it's probably too late to make that move.
Yes.
And so,
or too late for that move to work. It's not too late to make it, but it's too late for that to actually work.
Fair enough. But then here we are, where I know a lot of our clients are they're settled in their houses, and the IRS is kind of like, well, okay, there's value in that house, that $300,000 $300,000 worth of equity
it-
is thinking, well, you could sell that house and then suddenly have liquid 300,000 to just pay towards the IRS. Except in a lot of our cases, the clients have nowhere else to go. I mean, they can't just sell their house and then be homeless.
Well, that's that, and that therein lies the problem. And the IRS can be negotiated with. The first way, you can't say, okay, I can't pay the IRS, therefore the IRS should give me a real low offer and compromise number or leave me alone if I'm sitting with some serious equity in my house. I mean, that doesn't. The IRS has to go through an extra process, if they're going to take and foreclose upon somebody's principal residence. And in fact, that doesn't happen very often. It can, and I've seen it happen. But generally speaking, if there is, a reasonable but not huge amount of equity, the IRS often leaves that alone. There is kind of this 80% rule that says the IRS is really only expecting to get about 80% of the equity in the house. So if you had a $500,000 house with a $400,000 mortgage, the IRS is probably not going to seriously look at doing anything to take that house. Usually, if you have a $500,000 house and you want to settle with the IRS, get them to release the lien. If you come up with $400,000, somehow they will usually release the lien because it's 80% of the equity in the process. So there is some amount that the taxpayer could, if they handle things correctly, still get out of the process in the way of equity of their house.
In this disclosure, I mean, they ask for amounts in bank accounts too.
Well, when the IRS has this basically 433A and B.
Are they able to peer into bank accounts and talk to the banks directly without your?
They can summons any information they want to the bank. The bank has to give it to them.
What is their their process that the IRS has to go through to be able to do that?
Yeah, there's a summons issued to the bank, and then they issue you a notice the summons has been issued to a third party to gather information.
Is there some threshold amount that you have to owe before they'll, if the IRS will initiate that?
No, I don't know what amount that you owe. Yeah, I mean,
I'm just wondering how easy it is for the IRS to do this if they have to wait. They have to wait for it to. Okay.
Pretty easy.
Okay.
Generally speaking, if you have less than $10,000, they don't go through those extra methods.
But if you're like, I'm not going to give them my bank account information, let them just try and get it, they're going to get it, is what you're telling,
Well, I mean, yeah, you've given your bank your social security number. I mean, they have ways of finding it. They also have ways of compelling it. I mean, that's basically, you can do that. Then they can issue a summons. You don't do, you say, okay, I'm not going to tell you. Then they go through summons enforcement. They find somebody in the Justice Department who will take the case. And sometimes the Justice Department gets involved in some terrorist thing or some other thing that it's harder for the IRS to do that. But then they will take you to take Justice Department takes the case. They write you a letter saying you can do this. If not, then they take you down to then they can set a hearing in federal court. I did get a call a few years ago after somebody had done that. I'm not going to do that. I'm not going to do that. Call me. It's okay. The judge has placed my client in a federal detention prison and won't release him until he produces the stuff the IRS has been asking them to summons.
Okay, so
and I think which then he's had change of heart, and I got together with his son and we produced enough documents to convince the IRS counsel and the Justice Department that the judge would be allowed to release the gentleman from his temporary stay.
So the question of what can IRS collectors do is a lot. The answer seems to be a lot. The IRS collectors have a lot of power.
They are the government
to get the information they need to come up with a number that you owe and what you're worth and how much you should be able to pay them. Okay, well, say you're in this situation and maybe you're not necessarily not disclosing. You maybe want to try to work with them. How should you react?
And there are a number of different ways to react, and a lot of times you can do things to kind of slow the process down, kind of help get your affairs in order, get things where you would like to be. So, and the IRS is a big bureaucracy, and sometimes they'll have somebody in charge of a file, and they will work on it for a week, and then you give them a little bit of information. You don't hear from them for 3 or 4 months. In the meantime, you can kind of have some freedom to do without a lot of restrictions in that 3 or 4 months. But ultimately, if the IRS persists, and the bigger the number, the more likely they are to persist. The more times you have been in a hole with the IRS. And by why I mean that, if in 2011 you had a problem, you didn't fix it to 2014. In 2015 you had a problem, you didn't fix it to 17. Now 2023 rolls around, you've got a problem. I mean that you are sort of a repeat offender. You get less flexibility, and the IRS may be more active in pursuing you with regard to that. Also, if you accumulate debts, I mean, I still have a 2011 debt that hadn't been paid. I got a 2014 debt that hadn't been paid. I mean, and the more years that are involved, the more money is involved, the more likely the IRS is to continue to pursue that. And generally speaking, I advise cooperation. I advise disclosure, but never do it too early, and never do it any more than is necessary. Generally speaking, don't provide information that is not asked for. Now, some exceptions to that is if you have a child with special needs, or a spouse that has some sort, or you have some excessive medical need that is going to blow the standard budget of what your available resources would have. In which case, I would at the right time in the process, make that information available, and try to use it to reduce.
And I guess that was my question when I came to you with this topic. Was it seems unfair, like going back to the client who's sharing his house with his spouse, and if he's open to the idea of disclosing to the government and trying to come up with some offer and compromise or installment agreement, that he would have to disclose the entire value of this house, even though they don't plan on moving. It's their main property, their main primary residence, and has been for many, many years. And there are good reasons why they want to stay in that house. And I was just like, well, it seems unfair. Are there not? And it's a regulation. It's in the regulations. There's a statute and everything that says the IRS can look at the whole value of the house. So I thought, well, there's got to be exceptions.
Well, and the exception that may apply there is how fast they would take that house away. Because of some special circumstances, special needs, and then they may not get the extra approval for procedures to take the house away.
Okay, and then
but at the same point in time, that's the IRS is not going to say, but because you're in a situation where you need the house for the next 3, 4, 5 years, doesn't mean we're going to give up our lien rights. Doesn't mean we're going to let you get by without paying us. I mean, we can kind of put a lien there, put it on hold, and when the circumstances change and you're either forced or ready to sell the house, we want our money.
Well, let's say you live out your old age and you die in the house. Maybe not living in the house, but you die while it's in your name.
Yes.
And the lien is still there.
And the lien is still there, and your probate estate is still obligated to pay the government.
So
I mean, you don't get out of paying taxes by
you can't
dying.
say I then devise the house to my children.
Subject to the tax lien.
Okay.
So the children can get it. The children move into the house, but the IRS is still there and could still foreclose on their tax lien. Now, tax liens have a 10-year life, and in order to go beyond that, the IRS has to go get a judgment, reduce the tax lien to a judgment in order for it to continue. And sometimes they don't do that. Sometimes, and particularly people that have modest houses with modest amounts of taxes due, that they file the lien. So if you sell that house within a 10-year period, they're going to get their money. And if they don't get around to doing the process, or don't think it is worth the effort to go get a, federal judgment and the 10 years expires and they are by statute forced to release lien. I have seen, several examples of people who kind of outlasted their liens.
So if you're not in a hurry to sell, you're not looking, to relocate.
And it's not
Florida.
a big enough debt that the IRS is gonna foreclose on you in the process.
Then it might be worth just waiting it out.
Waiting it out. Now, you still have to deal with wage levies or attempts to garnish bank accounts and other collection techniques, other assets the IRS may try to go. But your house, if under certain circumstances, if you're willing to stay there and not be able to refinance it, not be able to sell it, it may be that you could survive the 10-year period.
And Hap tries to think of some, creative solutions to at least live with IRS debt.
And I mean, the trick, I think, is, or my approach is generally, don't think you can get out of the debt. Let's figure out how little you can pay without getting into serious trouble, and how long a period of time we can keep you out of trouble.
Okay, so to kind of summarize, what can IRS collectors do? A lot. And how should you react?
I think the answer is proactively.
Yeah.
I mean, that there is, you need to get good advice. You need to not ignore them, is the first rule. And on the other extreme, you don't need to invite them in to to your house for coffee and sit down and tell them your life story and about everything that you have and do and touch and might do and stuff like that. So somewhere between there, you are going to need to give them information, but don't be in a hurry to do it, and only give them the information that they need.
Yeah. And if you're not sure how to talk to them, you don't have to. You can engage representation and we'll do it for you.
That's generally speaking. I like to get a 28, 48 power of attorney so I can talk, or one of my lawyers or accountants can talk to the IRS, because sometimes clients don't know what to say. Sometimes clients say something that is wrong, and the only way to not say something that's wrong or stupid is not say anything at all. So let your representative go in and talk to them. And if the IRS agents ask a direct question, well, does this client have, gold bricks buried in their backyard? The client might have to answer that, yes or no.
Yeah, but usually
I'd have to say, I don't think so, but I'll check.
And usually I don't know the answers to the question, so I'm just, I don't know. I'll get back to you.
And if he does have them going, we had another conversation we got to have before we figure out how to disclose that to the IRS in the process, or maybe the Justice Department, or maybe I send it. And there are some cases, I'll add this to the conversation. There are some cases where I don't want my client talking to the IRS because there's some criminal exposure there, and I'm going to send them to a criminal defense attorney that handles white collar crimes, tax crimes, whatever, and they're probably going to wind up taking the Fifth Amendment to a lot of stuff, and that is an option. To most taxpayers, I don't.
Say that took a turn. Probably that's not you.
That's probably not. But that's in this conversation. That's one that we may have another podcast on some other day. But that's the extreme. So you don't ignore the IRS. You don't ignore the IRS. You don't give them everything. You talk to a lawyer. You figure out what you need to tell them, and you move on from that.
Okay. Well, Hap, thanks for being with us.
All right. This is Hap May with a Legal Play.